whenever the conversation has come to India and US and its tariffs, we have said we don't know what is going to happen next. And this is exactly what has happened yet again. India's tariffs that has been placed by US have been changed again, and there is so much ambiguity around it. But you might think why this has happened again. What has US done? What has India done? What has Russia done? But this time it is not geopolitics. It is about Constitution and Supreme Court and how they intersect with global economics. Because with one intervention of US Supreme Court, the whole landscape of India's export has changed in a single day. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to talk about this US Supreme Court judgment which has made all the global tariffs placed by President Donald Trump and his administration null and void. So what will happen next? What has been given as a reply by the administration, and where does India's tariff stand as of now? That will be the important dimensions that we are going to explore today. So let us begin with understanding that what exactly has happened. So the first in this whole overview is the fact that the global tariffs that have been placed by President Donald Trump and his administration, they have been labeled as illegal by US Supreme Court. Now this came in a very important 6-3 ruling, and we will be discussing a very important dimension here, that what has been declared illegal, what was the exact provision that President Donald Trump and his administration was using, and what has been said by the US Supreme Court on that. But before that, you must be thinking that what is the scenario of tariffs now? Are they 0% for India? But unfortunately, we are not that lucky that we have landed at 0%. As of now, we are positioned at a place where new 10% global tariff have been put. Now, this has been put across the countries from US's end, and they have said this is only temporary. We are placing it for 150 days. Why? Because once our global tariffs have been rendered null and void, this is the import surcharge we are going to have. The administration and also President Donald Trump have clearly gone ahead and showed disappointment, which is something rare that you will see in the Indian constitutional setup and the polity we are present. So towards the end, we will also move towards understanding that how Indian polity and US's polity are set apart in terms of constitution and also separation of power. Now, as it has been announced as a new 10% import charge is coming in. So for India, as of now, it would be safe to assume that we would not be paying 18% that was brokered in the Indo-US trade deal that we have recently signed. But at the same time, there is a lot of ambiguity around it, because a statement has also come from Donald Trump that nothing changes. India has to pay what it was paying, that is 18%, and this has been said after the Supreme Court ruling. So there is a lot of ambiguity, but still this Supreme Court ruling brings up a very important angle in the whole constitutional setup itself. So on that note, let us move to understand that what exactly was the center of this case. So when we are talking about the global tariffs which were placed by President Donald Trump and his administration, they were using the International Emergency Economic Powers Act. Now this was the main statute of 1977. They were using to bring in the global tariffs that we have been talking about since the day President Donald Trump has set his foot in White House. Now, when we are talking about this particular statute, this is the one that allows the President of US to regulate imports in order to address national security, foreign policy or economic threats. Now, as I said, this was the main use of this statute that resulted in global tariffs. Now, this is where US Supreme Court has stepped in and said this statute that you are using cannot be used in the regard that you are using, No other president has used this previously in such a manner, and this is not an emergency situation. There are 10 clear reasons which have been given out in the ruling which make it clear that this particular global tariff under the given statute remain null and void. So that is why President Donald Trump has gone for another statute. So that is why President Donald Trump had to use the sections of Trade Act of 1974 to bring in the new 10% import surcharge that he has placed. He cannot rely on this particular statute anymore. So this is the whole story what has exactly unfolded. As of now, as per the ruling, India will also have to pay 10%. That is the import surcharge, and because we have discussed this in detail so much previously, you would understand that yes, it is a relief. How much and how, we will be talking about this, because when we are looking at other countries, especially such as Bangladesh, because US has also entered into a trade deal with Bangladesh where Bangladesh gets entry at 0% for certain quota. So in that situation, yes, we do not have the comparative advantage, but yes, coming from 18% to 10% is a definite relief. Now straight up, let us move a little back to understand that what has unfolded in the last 2 years. So if you see the tariff evolution, especially since President Donald Trump has taken up the position in White House, you will see in the initial period we were placed with 51% tariff. Amidst this, 26% was the reciprocal tariff and rest we had as the punitive tariff. That was because we were buying Russian oil. Then finally we were somehow able to arrive at interim trade framework, that is the Indo-US trade deal, and we are positioned at 18%. In between this also there has been a lot of threatening of tariffs and more. So this also shows us the fact that bilateral negotiations were already affected because of the geopolitical stature of India and US, but now the domestic politics and the domestic law also seems to have an impact here. And in this context, it becomes very important for us to understand certain very important factors around this tariff evolution itself. So when we are talking about certain factors, I will be starting with the direction of it. So when I am talking about direction, we get to see that the direction is declining. But the problem here is that the declining direction is temporary in nature and it is also reversible. Another factor that you have to keep in mind, that this is not coming with bilateral negotiations. This is coming because of domestic law and the domestic polity setup itself. So we cannot rely so much so on this 10% because we don't know how much it is going to last. But if it is here to stay, then we also need to look into that what it is going to bring for India. Is this a good news? Is this a bad news? Where does India stand for this? So for the starter, as I said, yes, it comes as a relief. Short-term effects will be positive because lower tariff easily means that we have better priced exports. So let's just say multiple countries are sending their goods to US for selling. Whichever country has better priced goods, for example, India, if it is selling a good for 100 but other countries are selling it for 110, there is a possibility that Indian goods will be selling more. So we have the export advantage, and in this context our export margins will also increase, orders will also increase, and even with sectors such as MSMEs which have very limited margin, they will also grow. So this will help us with our ambition of becoming export-oriented economy. But at the same time, we have to look into medium terms risk which will come along with it. For example, when we are talking about the temporary validity, as of now the 10% is only for 150 days. We don't know if it will actually last for 150 days or it will be winded up before that, because President Donald Trump has vowed that we have other ways, Supreme Court cannot stop us. And we also have to understand that the negotiation leverage the finality that we were feeling, okay, fine, we have some deal, we are at some platform, that has also shifted in a very different direction. Now, add to this the global chaos that US is part of, be it the US-China rivalry and be it US threatening the very existence of NATO. So, all of this also impacts the negotiation. So, as of now, we do have multiple benefiting sectors from this particular reduction, that is textile and garments, we have pharmaceuticals, engineering goods, light manufacturing chemicals and all of these. But at the same time, we have to understand that our tariff is not zero, which is going to be a problem. We do not have any preferential trade agreement as of now with US, and there are free trade agreement competitors which have free trade agreement with the US, and they will outperform us in this whole situation. So, all in all, we get to see that immediate tactical gain is present, but long term what we will be able to do, what will outlie and what will come in front of us, we don't know as of now. So, one direct question that might be coming into your mind, that ma'am, you have told us so many things, what does it mean? In very simple language, as of now, India is in a relatively better position. India is no longer facing discriminatory tariffs. Competing exporters, they will be taxed equally. So, that's a good news, and level playing field has improved the situation for us. But this advantage is not going to translate into humongous growth. That is the issue, because India still does not have a free trade agreement regime, India still does not have a preferential tariff regime, and supply chain alliance frameworks, India is not part of many. But the good news here is India has just signed entry into Pax Silica. So this is one supply chain alliance that we have been added to. But as of now, if you have to summarize all of this, all we get to see, we were a disadvantaged exporter to US. Now we have become a neutral competitor, but we are not in an absolute positive place from negative. We have come from negatives to 0 or maybe 1 or 2, but there are bigger numbers that we need to achieve and we would want to. Now, on this note, we will straight up move to a very important question that I started in the conversation, was about that how is this setup different from India's polity? Because we have to understand that how did US Supreme Court intervene, and can India's Supreme Court intervene in such foreign trade policy matters? Is that a possibility? So, in this context, we have to understand that the core constitutional doctrine is the fact that authorities over taxation and foreign commerce, they lie with Congress. Now, when we are talking about Congress, it is the legislative, that is law making arm of the federal government. So, when we are talking about the whole authority, that who will be taxed and what will be the foreign trade like, that is decided by the Congress. That means in this situation, the president can easily impose tariffs only when it has been authorized by law, and if court finds that earlier tariffs have exceeded the delegated authority. In these only situations, we see a possibility. Now, in this context, we have a definite way where we see Supreme Court intervene, President imposed the tariff, and court found that this is not the usual statute that is used, or the authority might have been exceeded here. So, in this context, what did we see? We saw intervention of Supreme Court and the verdict. But if we compare it with Indian situation, will this be a possibility? Yes, it will be a possibility, but institutional context will be very different for India. For example, if we talk about power over tariffs, in US it is Congress which has the primary authority. In India, it is Parliament. Pretty much the same thing. Can you tell me in the comment section, are the same thing? Because when I told you about Congress, it is the law making, legislative part of federal government. And when we are talking about Parliament, it is also responsible for law making. So, is it the same thing? When we are talking about delegation, we get to see that it is very limited and specific in US, but when we are talking about in India, it is very broad. That is done by executive. And when we are talking about judicial tradition, there is very strict separation of power, but India, we have flexible separation. So we have all the bodies checking on each other: executive, legislative and judiciary. So when we are looking at executive authority, especially for India, this will give you a better answer that executive authority is wide when we are talking about delegated legislation. So here the scope for executive to act is way wider. So intervention in US's context was absolutely right, and it is possible because executive power and authority, they are narrow. But when we are talking about India's executive, here we have wider delegation. So again, there is scope for Supreme Court to enter, but the context is very differently set here. So all in all, when we are talking about both of these comparisons, we get to see that US, there is a very strong review of what executive is doing, especially in terms of economic actions. But when we are talking about Indian courts, we usually see that the government is responsible for economic policy until unless there is a direct constitutional violation, there is something associated with arbitrariness, and there is some illegality related to procedure. Now, what are your thoughts on this? Let me know in the comment section. We have already done a detailed analysis when we are talking about the relationship in terms of tariff, what it impacts India in the previous video. You can go and watch that in detail. And I will be leaving you here with a practice question. You can put down the answers in the comment section. That was all from my side. Thank you so much.